that will militate against grant of bail, even though it's a constitutional right.
Yes.
You know, you were referred to the case of Danson Mugunya by my learned friend, Mr. Wandugi, in which matter I appeared. And that authority is before you. Your Honor, I will kindly urge you to look at page 12 of that decision. The fifth and sixth paragraphs. And in my humble submission, you will note what the judge in this matter observed on the matter of interference with witnesses. And very quickly, let me just read out one portion, very briefly. I am not persuaded that there are any risk of interference with witnesses or destruction of evidence. If there is any sign, and the key word here is sign, if there is any sign or proof that this has taken place while they are still out there, then the state is at liberty to apply. What is the judge saying? Honorable Justice Ibrahim, as he then was in the High Court, was alive to the fact that witnesses need to be protected. And even in granting bail, he put a rider to it. Should they go there and interfere, come back. In my humble submission, you are handling a situation completely different from the situation that was presented before Honorable Justice Ibrahim. In this sense,
Yes.
Inspector Walter Oginga tells you in the affidavit that phone calls have been made to witnesses. There have been internal memos advising persons not to cooperate. That was completely absent in the Danson Mugunya case. So persons who have conducted themselves in such a manner, and Your Honor, they have not responded, they have not rebutted this, either by way of oral submissions, at the very minimum, or playing by the rule by affidavits by themselves. Why is it important? Your Honor, I'm almost certain when my line friends rise to respond, their first point will be the burden lies on the prosecution. That is true. But what is the burden? Your Honor, I'll rely on the case of KKK versus Republic. It's in a bundle that we supply to the court. 2017 EKLR. And the balance, the burden of proof at this stage is on a balance of probabilities. In my humble submission, where we place material before a court that meets the basic threshold of compelling reasons, and where that material is not controverted whatsoever, then we have discharged our burden. Your Honor, I urge this court not to hold us to a higher standard of proof beyond a reasonable doubt. We are yet to get there when we go to trial. Your Honor, if any party doubted Mr. Oginga's averment, then they had the option to cross-examine him on the contents of his affidavit. That is the law. The only recognized way of testing the veracity of the averments. That again did not happen. So that, Your Honor, this morning you have before you accused persons who are telling you we are fit for admission to bail, but they have completely shut their eyes on a very crucial matter that has been placed before you. It cannot just have been by way or sheer inadvertence on their part. Your Honor, yet on another point of close association between accused persons as a matter that you need to bear in mind, these persons, and on that I'll rely on the case of Jane Muthoni Musheru, Republic versus Jane Muthoni Musheru, 2017 EKLR, at paragraph 25. This is a decision by Judge Joel Gugi, who had to deal with issues that concern persons charged with the offense, with a criminal offense, and have close ties with others who have vanished. And the judge notes, and he actually proceeded to deny bail in the matter, that where such evidence, just like it has been demonstrated before you this morning by my learned friend, Mr. Njeru, you have persons who have already slipped out of the country. Or at the very minimum, they are not before you. Against whom we have applied for warrants of arrest. These persons are so key to this trial, as you will note from the charges. Who are they and why are they important, even as you consider the matter of bail? Your Honor, these are directors of the subject company that benefited from this tender. We have demonstrated beyond peradventure that any attempt that they have made so far to give as a reason for their absence is at most suspect. Much to the chagrin of the good professor, when my lion friend Mr. Kimadi referred to their very own document, perhaps again, without casting up aspersions, you note from that document, medical reports have been presented, sorry. But then, Your Honor, now it is convenient when we attack that document for you to be told this is a medical report. It can be prepared in the absence of an accused person. But Your Honor, the very basic rule would be this. If a document is being prepared for purposes of transmission to court, then he who comes to equity must come with clean hands. Their hands are soiled. We have shown by way of this statement by John Anthony Mungai that take every word that comes from that direction with a pinch of salt. When they urge you not to consider them flight risk, please treat that with the necessary circumspection. It takes a very bold man to appear before a court, present documents, present a position, while knowing too well that it is factually incorrect. At least we got them on this one. Your Honor, compelling reasons have been interpreted by the courts since the promulgation of this constitution severally. And it is now settled, even from the same authorities that my lion friends relied on, the case of Nzioka, which appears to be the locus classicus recently, that was from the High Court. The judge also considered that matter. And all that the judge says in that decision is there has to be a basis, not blanket statements. And we are urging you to find there is a basis. Phone calls are being made. Memos are being manufactured. Witnesses are on notice. Do not cooperate. That, in my humble submission, should be sufficient material that this court should look at and be minded. Should be minded to decline to grant bail. Attempts have been made to discredit our affidavit on the basis that Walter Odinga has not been granted any authority. That came from Counsel Migosi. And I was almost tempted to believe he was right. But if you look at Article 245 of the Constitution, you will note, Your Honor, that police officers owed the residual investigative power in this country. In fact, anybody else, a creature of statute such as EACC, is conferred police powers so that this is the donor. They donate police powers to other agencies.
All right, so that is what is happening at the Milimani Law Courts. Of course, the bill